Good afternoon, everybody. I hope you're well. Just before we kick off and I hand over to Amy, I'm just going to run through some brief housekeeping notes. First of all, I just wanted to draw your attention to some of the forthcoming sessions that Surrey Law Society are hosting before Christmas. A few of them are on screen now, so you'll see we've got a webinar, an online forum, and we've got our annual quiz coming up on the 30th of November. We've also got our AGM on the 7th of December, which is online. So if you view the website, you'll see everything that we've got coming up before the end of the year. Moving on to housekeeping. If you'd like to ask a question during the webinar, you can do this by typing that into the Q&A box. You can do that anonymously if you tick the relevant checkbox. If you'd like to speak to Amy directly, you can do that at the end of the webinar. If you just raise your hand, we'll unmute you and ask you to speak. The webinar is being recorded, and I believe you will be asked to complete a feedback survey automatically when you log out. So if you could do that for us, that would be really helpful. Right, with no further ado, I will hand over to Amy. Thank you, Amy.
Helen. Hi, everybody. My name is Amy Bell. If you've not met me before, I'm a solicitor and director of a business called Teal Compliance, and we help law firms with all the rules and the regulations that they need to follow. I'm also a volunteer at the Law Society. I chair the Law Society's Money Laundering Task Force, and so that means I represent the solicitors of England and Wales when it comes to anti-money laundering at government, with law enforcement, with the SRA, and I am here today to run my financial crime update, and it's not just about AML anymore. I've got some slides here to share with you, and these will be available after the session, so anything I'm talking about is on the slide. Don't feel you've got to make a load of notes. This session is really built for those people that are in charge of AML in their law firms, but I think it's a good it's good content for everybody that needs to think about compliance generally in the business. I have for a really long time spoken about AML, and exclusively AML really. It's been the hottest topic, and we'll see in today's session that it's still a very hot topic for the regulator. But it's the financial crime picture is widening, and we'll see why and how that is happening with some recent legislation changes, and how we will need to start thinking about financial crime compliance wider than just AML and terrorist financing, which is what we've been kind of used to for a while. We're going to have to start including in our programme things about sanctions. There's a potential offence that may or may not hit you, but we'll see as the SRA's powers are being extended, or powers and responsibilities are being extended when it comes to financial crime. I think the questions they're going to be asking you about what you've got in place will start extending to outside of just AML. So I've got a few little updates for you, and I think it's the best place to start is thinking about the current AML landscape. That's what we're familiar with AML, so let's start there. I've been in this world now for 18 years working in AML. I've been volunteering at the Law Society since I think 2012. 2011, 2012. And in that time, I have recognised how volatile or vulnerable to politics anti-money laundering is. We back in 2002, 2003, when we got the law and we have first started to have to be doing client due diligence and reporting suspicious circumstances, it kind of felt very remote to us, like, well, this is something that happens in banks, it's not what happens here. But nevertheless, we've got all the processes and we've gone forth, and people, I think, thought that we were doing quite well when it came to AML, especially up to like 2015. The SRA did a study of 250 law firms and found that most firms had good processes. However, in 2015, there was something called the National Risk Assessment. This is a government project that looks at the country's vulnerabilities to anti-money laundering, to money laundering, and what we should do to prevent it. So what we should do for anti-money laundering. And in that 2015 risk assessment, they looked at each sector, but for the legal sector, they said that we are high risk for money laundering, low risk for terrorist financing, but high risk for money laundering. And so that really was at odds with what the regulator was saying at the very same time, which is, I think they're doing everything they should be doing here. I think it's all fine. But then we've got the government saying, well, the legal sector is high risk, and we're high risk in a few areas: conveyancing, company or trust provision. So if you create companies or trusts, or you're managing them in any way for clients, that's high risk. Just the very fact that the majority of us have got a client account makes the legal sector high risk. That isn't to say we're all doing money laundering. That is to say that when a baddie wants to launder money, there's a high risk they'll target a law firm to do it. And so this political pressure started with a phrase that they coined in 2015 of professional enabler, that lawyers and accountants were professional enablers of money laundering, as in, well, they've got a variety of interpretations, actually. One, we're turning a blind eye. Two, we're not doing what we're supposed to be doing, and therefore there are vulnerabilities and gaps that the baddies can exploit. Three, some of us just make it our career to do money laundering for clients. None of us, obviously, on today's call, but that there are the baddies, and there are cases where baddies have been have recruited lawyers into their gangs, and solicitors have gone to prison for it. So this label of professional enabler then led to a kind of almost like a snowball effect of pressure on us that is influenced by global events. So the first thing I kind of flagging up there is that, the geopolitical climate and the issues that are going on, people are wondering, whether, for example, the London property solicitor sector has benefited from money from Russia, which actually everyone was, quite happy for people to accept. But suddenly, when Russia became something that people were concerned about, their behaviour, people were concerned about, sanctions came and things like that. Suddenly, people are turning on the lawyers and going, well, what were you doing acting for them? And of course, we can act for clients. That's the whole point. We must act for clients. That's, maintaining the rule of law. But this pressure started to come on. Well, what are the lawyers doing these things? And I think with the continuing situation in Russia, Ukraine, the developing situation over there in the Middle East, and concerns about that widening to be a wider conflict, the pressure on what are you doing to make sure you're not facilitating anything, including terrorist financing, is going to keep coming. There's also the Financial Action Task Force requirements. In 2017, 2018, we were mutually evaluated. That means that we're audited as a country, and all parts of the regulated sector, or at least regulated for AML sector, are tested, including the legal sector. And they had some concerns about the ability of supervisors to properly supervise their regulated sector. So if you are in an SRA regulated law firm, I'm guessing most of you are, your supervisor, technically according to the law, is the Law Society of England and Wales, but they delegate that to the Solicitors Regulation Authority. They're completely separate bodies now. And so the SRA is your supervisor. But there are across the legal and accountancy sector, there are 23 different supervisors. And the concern was having such a fragmented supervisory environment meant that there could be weaknesses that criminals could exploit. So worried about what FATF thinks about what we're doing, that led to more pressure again on the lawyers. There's been 2 more national risk assessments since that first one in 2015, both of which continue to peg the legal sector as high risk. And the last one actually added work type to the high risk areas of property, company, service, company and trusted services, and then the client account. They actually added sham litigation. Now, normally when I talk about sham litigation, or historically when I talked about sham litigation, I'd be talking about essentially an attempt by the criminal to infiltrate your client account by getting you to accept money supposedly in respect of a debt, but really it's a sham just to put the money through the client account and abuse of the client account. This sham litigation they came up with in the 2020 National Risk Assessment is about people wanting to pursue litigation till the end to get a court order, and the court order be the justification for moving the money between the parties to add a layer to disguise that this money is really criminal property. And so, you know, we're supposed to be looking out for that. We haven't, as far as I know, started the process of preparing the next National Risk Assessment, but we're due one. I would expect to get one in 24, probably. And FATF are due back, I think, in 2026. And the government between now and then really want to show an improvement. And so how that plays down to us is that we see much more regulatory activity. Back in 2015, you know, that study they did of 250 firms was the first bit of AML work they'd done. There was one person who was the MLRO dedicated to AML at that point, and then they used, you know, investigations team if they thought they had a problem, or they used regulatory managers to engage with the firm. Since then, they've built a team which is probably about 30 strong. And I think in the kind of advert for this session, I probably told you they were asking for an extra 10 million of funding to grow the team at the SRA even bigger, such that they're seeing about 250 firms a year on average now. So, and they're prioritizing firms that do high risk areas. Obviously, why wouldn't they? So they're going to be much more likely to have you on the list for speaking to, visiting, asking you to send documents in, if you're doing conveyancing, trust or company work, and you've got a client account. If you are a niche employment lawyer, I'm not saying they're never going to knock on the door, but you're probably going to be further down the list of risk, because that's not where the AML risk lives. It's in those firms that do what they consider to be the high risk areas. So I would say, folks, and if this is the first time you've met me, you won't know this about me, but I generally don't approach compliance in a you should do this because it's what the regulator wants. I generally approach compliance in it's the right thing to do, and a byproduct of that is that the regulator's happy. But I would, you know, wouldn't want you to kind of underestimate the involvement of the regulator. It is probably, if you are a kind of high street local law firm doing some conveyancing, they won't release their methodology at the SRA, but my best guess would be it's probably about a 10% chance in any given year that you'll have contact with them. That is, you know, that's way different than it used to be, because you practically never have contact with them. But yeah, they're continuing to see and wanting to build a team so they can see more law firms. So as I say, that's not their figure, 10%. That's just a bit of magic maths on my part, but thinking about the numbers of firms that they need to get around, and there's kinds of things that they're looking at. When they do get in contact with firms, there's a few different ways that they interact with firms. Firstly, they might do a call out for documents. So sometimes what they do is they'll say, please send me your firm-wide risk assessment, or please send me your PCPs, your policies, controls and procedures. And so that's a desk-based review. They're not in contact with you in any way. Secondly, they do what are called inspections. So inspections are a bit like an audit, a bit like an independent audit, if you've had one of those, where they will look at the policies and procedures, they'll interview some people, they'll look at some files, and then they'll come back to you after that. The third interaction that they have with firms is thematic work. So they'll pick a subject that they're interested in, that they want to know more about, and they will contact firms about that. So they did a mini thematic last year about sanctions. They also did a thematic about client and matter risk assessments. This year, they're going to be doing a thematic around training, AML training, and what training you're delivering to people, so that they can create resources to help you, for further guidance to help you. So the most recent one, as I say, was about client and matter risk assessments, and that has led to the publication in the middle of October of some guidance, some templates, and a warning notice about what they expect. And so, you know, there is an output to all of this work, hopefully, that you know, supports the profession, as well as being super clear on what their expectations are in terms of being able to discipline people who aren't complying. So this increased level of supervision is not going to go away anytime soon. And I think that one of the things I talk to my clients about quite often is, are you regulator ready? Are you sure if you get the call? Because here's what happens: if you get an inspection email. You don't get a call, you get an email. They give you a window to pick a date. That date can be in a few weeks' time. You can pick it at your convenience. Most people, as soon as they get it, pick the furthest one away. But the date that they want to see the documents is the date they email you. So even if you rush off and get it fixed after that, they won't give you credit for that. They'll be saying, on the date we contacted you, where were you now? So there we go. The other thing I would say while we're on this is that the SRA have been super clear that they expect most firms to have an independent audit. Independent audit is something that the regulations require if a firm is a certain size and nature. They don't tell you what qualifies as a size and nature to need it, but I think the things that they're talking about is if you are doing some of those high risk areas that we've talked about, conveyancing, company trust, and by the way, property law is not just residential conveyancing, it includes commercial property as a high risk. Or if you've got kind of a sizable firm, multiple branch offices, things like that, where the person who's in charge of the AML program isn't actually involved on a day-to-day basis with file opening and doesn't really know what's going on and is hoping that other people are doing the right thing, that's leading you towards being the size and nature. So probably not sole practitioners, probably, anything upwards of I can't give you a particular number. We have clients that come with kind of upwards of 20, 30 people, something like that, but we have done them for much smaller places that specialize in, say, conveyancing, and so consider that they've got a considerable risk. So if you haven't had an audit, I would have a think about it. They don't have to be done externally. What has to happen is the person conducting the audit cannot be the same person that put the policies and procedures in place. So sometimes firms might have a partner in the practice that isn't currently involved in the firm's AML program, maybe is joined from another firm where they were an MLRO and they know enough about AML to be able to audit it properly. Otherwise, as I say, there are external ones. There are some firms subject to conflict checking that kind of work in a partnership with other local firms and audit each other. But yeah, there's many ways to skin that cat. I should stop saying that. I always say that. I need another phrase for it. But there's many ways to kind of slice and dice the audits. But certainly, if you think you're in the size and nature category and you haven't had one yet, I would get one as soon as possible. They will ask for the audit report if you're selected for an inspection. Okay, so the last kind of change, we'll go into this a little bit more, that I wanted to say about was SARS reform. So I've been sitting on behalf of the Law Society on the SARS reform board for about 5 years. This board, it's just finished actually, and it's been reconstituted, but the board's remit was to support the development of new technology for the National Crime Agency to process subject access suspicious activity reports. That's the other one, subject access request. Suspicious activity reports. So, if you're the money laundering reporting officer and you are going to do a report to the police to get a defence against money laundering, consent, you have to go onto the SARS portal and fill it in. And the portal that up until recently everybody was using was something that was designed back in 2002, 2003. So if you think back to what your mobile phone was like in 2002, 2003, you could play Snake on it and that was about it, read text messages, that technology then is a world away from where we are now, but yet the tech we were using to submit SARS was still of that era. And so there was a big project kicked off 5 years ago to let's rebuild it, let's build something better that's forward facing, better user experience and things like that. And let's see how much more use we can make out of the information that reporters are providing us. So I've been on that board now, as I say, for 5 years, and we have finished the first tranche of work, which was delivering a new portal. So I'll tell you a little bit about that near the end and give you a link so you can watch a video to see how it works if you've not used it yet. But hopefully, the hope is, our kind of wish as a board was to have that system being utilised more by the law enforcement, local branches, and there's been a huge investment in local resources that understand the data that's in the portal and can help people build cases against baddies. And hopefully it means that the data will be better, be able to be analysed better, which means they can provide us feedback and more timely information on how criminals are operating potentially in our area. All of that remains to be seen, and there will be a new board constituted soon that looks at, right, okay, now we've got this new IT, what can we actually get out of it? So yeah, keep an eye out for that. I'll tell you about that at the very end. We've had some legislation changes. We have changes to legislation fairly frequently. The main piece of legislation in anti-money laundering is the money laundering regulations. We are still referring to the 2017 money laundering regulations. I'm sure you know this already, but one of the things that the SRA frequently puts up firms for is that they're still referring to old legislation. Your policies, your client engagement letters, any leaflets you send to the client about AML should all be referring to the 17 regulations now and not the 7 regulations. It certainly would pick that up if they'd assume that you hadn't done anything since the 17 regulations came in. If they saw that in your paperwork, there was actually a case of a couple of partners in a firm in Oxford fined £20,000, and one of the things it pulled them up for was an out-of-date policy. So yes, definitely make sure you have a little check of all your policies and procedures and make sure they're up to date. More recent amends, there have been several amends to the money laundering regulations, but the most recent ones have been in relation to that I need to tell you about 2 particularly. First one, this one about the obligation to just do discrepancy reporting. So discrepancy reporting was actually brought in by earlier amendments to the money laundering regulations, and the original amendment, if you like, was that if you were, during the course of doing client due diligence, to identify that there was a difference between what you were told by the client was the position in the company and what you saw on Companies House, if there was discrepancy between the two, you would have to report it. Now, there were some caveats to that, and this is covered in guidance by the legal sector, in the Legal Sector Affinity Group guidance. The caveats are that if it's just a typo, not a problem. If it needs to be a material error, like it's showing that on the PSC register, it's showing these people as the shareholders and the beneficial owners, but it's really these people, that kind of stuff. The second caveat is you might not report it if the client is trying to fix it, and you've said, oh, by the way, client, did you realize that this was wrong? And they're like, okay, yeah, I'll get it sorted. If they're going to get it sorted and actually rectify the position, then you might not need to report it. But if they're not doing anything, ignoring your advice and saying, no, I'm not going to change that, then you would have an expectation. There's an expectation that you would report it. So the change that was brought in by the amending regulations in 22 were that the original ones were on doing file opening. They just added or during the course of the matter. So if you identify that discrepancy through the course of the matter and you know it's not been updated, maybe you're doing some ongoing monitoring and you're just checking Companies House periodically. If you become aware of discrepancy ongoing, there's also a reporting obligation. For most people, what we say to staff is, if you notice this discrepancy, report it to the money laundering reporting officer, and then the money laundering reporting officer can look at the guidance from Companies House about what they've got to report. So yeah, just a small change, really, going from on file opening, if you notice a discrepancy, this is what you've got to do, to on file opening, or throughout a matter, if you notice a discrepancy, this is what you need to do. The second one that came in second thing to tell you about that came in with those amending regulations in 22 was about proliferation financing. So proliferation financing is the business of financing transactions for components of weapons of mass destruction, basically. And so only relevant really if you are doing deals that could have the types of transactions where something is being transacted that could be used as a weapon of mass destruction. We usually call these dual use goods, things like computer chips, chemicals, things like this that could be used. The transaction appears to be for the sale of 4 million computer chips for building mobile phones to somebody, but actually in reality those same computer chips can be used to put navigation systems into missiles or something. Now, it all sounds very fanciful. Happily, the the SRA believe that proliferation financing is a very low risk in the legal sector. It would only affect a certain number of firms that are dealing with either international transactions that with jurisdictions where proliferation financing is risky. Think places where that that they've been banned from building weapons, but they seem to do it anyway. North Korea, Iran, places like this. Or you're doing big financing deals. So for the vast majority of local smaller law firms, this isn't really a big issue. But what the regulations require that you do is you consider if it is an issue for you. And conduct a risk assessment. The SRA have said that this risk assessment could just be a section in your money laundering risk assessment. You don't have to create a brand new risk assessment for proliferation financing, but you definitely have to carry one out. So if you haven't done that already, you need to reflect on proliferation financing, what it is, whether you think you do any work types that will be exposed to that, and if so, how are you going to make sure that everybody in those departments knows what they're supposed to be doing, what policies might you need about that, what sign-off might you need for those deals, what red flags would there be. I mean, in proliferation financing, the red flags would be is that the transaction appears to be one thing, but it's for a completely different thing. So there might be discrepancies in the paperwork. There might be parties that are ultimately connected. There might be a connection with a jurisdiction that doesn't make sense. There might be transactions involving countries that have weak import and export controls. So all kinds of different red flags. As I say, there is some guidance about this, the Legal Sector Affinity Group. So if you have a look, if you go into the Law Society, the main Law Society page, and Google proliferation financing, you should find your way to the guidance. If not, always give me a shout and I'll help you find it. If there is a proliferation financing risk, I think you do need to make sure you've trained everyone about it. I've started including it in all of our AML training, updating training we're doing for law firms. Just a quick mention, just so there's an awareness of it. And you might want to, if it's something that you think is relevant, include questions about it in your matter-based risk assessment that people need to do for AML, just so that you can demonstrate that the lawyers thought about it and dismissed it as a risk. So there we go. So I've got here potential new legislation. It's actually legislation, but it needs some more legislation to bring these things into force. So there will be more legislation coming. We've just had in October passed the Economic Crime and Corporate Transparency Act 2023. This builds on the Economic Crime Act from last year, which was rushed out after the Russian invasion of Ukraine. And if you remember, had something about the register of overseas entities in it, that owners of overseas property needed to make sure that they had registered, that they were in fact owners of that property, and that they'd had their ID verified, and that was noted at the land reg. So what happened was there's a whole load of legislation ready, including some of the stuff that's in Economic Crime and Corporate Transparency Bill Act now. There's a whole load of it. Before Russia invaded Ukraine, it was parked. It was kind of shelved a little bit, and it was a bit of there was a bit of political controversy. There was a particular member of the House of Lords who said, "Well, I'm resigning the party because you're not. I worked dead hard on this, and you're not doing anything." And then, literally a week later, or 10 days later, Russia invaded Ukraine, and suddenly this piece of legislation that had been temporarily mothballed was brought back. They looked at it and said, "What can we act straight away? We'll do that now, and then we'll come back to the rest of it as soon as we can." So this is the rest of it, if you like. It's quite a big bit of legislation. Not all of it's relevant to us, but some things that I think that you need to know are coming. As I say, whilst the Act is in force, a lot of the parts of it need commencement legislation, and so that's coming at some point. Or consultations about how to use things. So things to be aware of. Changes to Companies House is probably the big headline about this. One of the things about discrepancy reporting we were just talking about, it's about pushing the obligation onto the regulated population, lawyers, accountants, banks, to check the information on Companies House. Because it's super easy to open a company at Companies House, or it has been in the past, and there's not really any difficulties to doing that fraudulently. So you can put any old person's address down if you want. There's no checks on it. And the government, because the Companies House was essentially underfunded, was conscious of this, and that we're relying on information that's in Companies House, but we don't know if it's right. And that's where the discrepancy reporting stuff came from. That's where the overseas register for overseas entities came from. We're like, we need someone else to check this information for us. Obviously and predictably, the regulated sector pushed back, going, "This is not our job. This is a government job. Why are you making us do it?" And there's somebody called Graham Barrow that is a hero of mine, works in AML, and he's on Twitter a lot. And he has a company which looks at Company House data pretty much out all the time and flags up when they think there's some fraudulent things being created. Yesterday, gosh, what was it? I think it was some sort of businesses, beauty businesses, possibly they were. He said, "No way of this, look out that someone's created 23 new beauty businesses or something today." It just doesn't make sense. And so I think the government have conceded that they need to do better. There need to be more checks and balances on companies being created, information being lodged at Companies House. And so the changes to Companies House are a big feature of this act. Things like having to prove your identity when creating a company for directors and shareholders, restrictions on who can submit information on behalf of a company to make sure it's the right person that's doing it, the requirement to register, an email address that they can get in contact with you for potential checks on addresses to make sure that the company is there at that address or is going to be there at that address, and it's just not 500 companies listed at the same postcode. So those changes will be coming. They're not here yet, but hopefully that will improve things. They'll also end the requirement for companies to keep details of their own registers and make Companies House a single source of truth for corporate information. That's a big thing to do. So that won't be happening anytime soon. But keep an eye on that, especially if you do corporate work and you help your clients make sure that they stay compliant with their filings at Companies House. I think the big ticket item for the legal sector is the change to the regulatory objectives. So the government is introducing a new regulatory objective, which amends the Legal Services Act, focusing on the promoting the prevention and detection of economic crime. So this is significant. The role currently that the supervisor has is about prevention and detection of money laundering and terrorist financing, not economic crime. Now, economic crime is a big catch-all term for all kinds of things: fraud, bribery, tax evasion, all of these things, sanctions, they all come under economic crime. And so what the impact of this is it widens the regulators' responsibilities from just focusing on AML, which is a lot of their work has been. We've already talked about the work that they're doing there, to opening it up to be responsible for other types of financial crime that lawyers are exposed to. And what that means is, even in the absence of legislation, the regulator could start to say, well, I expect to see this, that, and the other that firms have got. So, if we take sanctions, which we're going to look at in a little minute, in AML, we know we've got to have policies, we know we've got to have procedures, we know we've got to do CDD, we know we've got to keep records, we know we've got to train everybody. Like there's a whole compliance regime built that we just kind of plug into because we know what it is. And when it comes to sanctions, there's no legislation telling us what we're supposed to be doing. It just says don't breach sanctions, full stop. But there's nothing that says what the compliance looks like for that. Fraud, similarly, there's nothing currently that says what you'd expect a business to do for fraud. Again, in the law, there's nothing that you'd expect a business to do in anti-bribery. But yet we do have bribery policies. We did do bribery training. We do have gift and hospitality registers. But the regulator, if you've noticed, never asked to see them. They're not interested because they didn't have until now an obligation to ask about it. So now this is changing. We're yet to see how they're going to use this power or obligation, how they're going to fulfill this obligation. But watch this space. It's likely to mean them calling in for, well, let me see you've got sanctions policies. Let me see you've got anti-bribery policies. And this is why today's session is called It's Not Just AML Anymore. because this one section in the Economic Crime Act is the thing that means that the SRA is going to be looking wider at economic crime, and therefore so must we. The other thing that they've got is unlimited fining powers for economic crime issues, which is massive. And personally, as someone who works in this area and has worked in this area for a really long time, concerns me greatly. The SRA recently had their fining powers increased from the original one, which was £2,000 without referral to the Solicitor's Disciplinary Tribunal for partnerships, or £50,000 for alternative business structures, ABSs. They got their fining powers increased to £25,000 for straightforward partnership law firms, traditional law firms, non-ABS firms. And as I say, the first time they used it, £20,000 for a couple of people in Oxfordshire, to partner practice in Oxfordshire. No allegations of money laundering taking place. It was just about the compliance. They didn't have the right policies, hadn't done the right training, didn't have the right information for staff. Staff didn't know the right stuff. But you know, so they're going to wield this this power. And a firm can appeal. I did check this with them because it was a bit opaque as to what a firm could do if they just didn't agree, because actually quite a lot of the things that have been brought to my attention of firms being disciplined, when you actually look at the allegations made by the regulator, I think if you went to the tribunal and said, well, that's not the law, that's just what they're saying they think the law is, or that's not what happened, that's just what they're saying they think it is, you might actually be successful in fending off some of the allegations. But most firms that I've come across just don't have the appetite to go to the tribunal and fight. And then what happens is they take the agreed fine, you know, the fine that's on offer, and then it becomes an agreed decision and just simply currently gets ratified by the Solicitor's Disciplinary Tribunal. They don't have to do that stage anymore. It's an internal process. They say, well, this is what we're going to fine you. And you can say, well, I don't agree with you. And I think there are 2 levels of appeal within the SRA before you would have to go to the SDT and potentially incur the costs, obviously, of the SRA and you if you lose at the SDT. So the Law Society have, you know, did object to these powers, continue to object to these powers. And I think there'll be a consultation about how they use these powers. Finding powers going forward, and so, you know, make your voices known if you've got a view when that consultation comes out. We will see. The other thing in the Economic Crime and Corporate Transparency Act is a new offence which is not thought to be in force until probably 2025-ish, which is failure to prevent fraud. Now, failure to prevent fraud is about a company is liable if they fail to prevent fraud by an employer or an agent of theirs against the firm or its customers. That's the kind of offence. It only applies to large companies. When this was going through Parliament, this was a massive source of discussion, because they're like, well, why are we keeping the small firms out of it? But the government were, you know, wanted to get it through and push forward for a large firm. So large firm means that you've got you have to have, it's the HMRC definition of large firm. So you have to have, I think, more than 250 staff and well, a combination of these factors: 250 staff, 36 million turnover, 18 million assets. So if you've got 2 out of 3 of those, I think you qualify as a large firm, and therefore this offence will take effect against you. The reason I put it on here, conscious that probably doesn't apply to anyone who's on today, the issue is that now that the regulatory objective's been extended to prevent fraud, even though those big firms are going to probably have to get policies and procedures and stuff like that to try and get a defence against any allegations of failing to prevent, I think that we all will end up having to do it, because the regulator's expectation will be cybercrime is a type of fraud, you know, theft from the client account type of fraud. And so I think with this widening regulatory objective, this will start to say, well, actually, what are you doing, firms, to prevent fraud in your business? So again, horizon scanning. But I do think that fraud, even if you're not a large firm, is going to be something that you need to start adding to your list of things to get done. Not do fraud, obviously. I mean, put the policies in place. So, sanctions. I'm sure you've heard about sanctions by now. You know, I've been training in this space, as I say, for 18 years, and we always had a slide on sanctions and explained it to people, but really it wasn't anything that that was that kind of high profile. But last year, the SRA put some guidance out. You can see the link on the slides to get to the guidance about their expectations with firms. And as I've just said, with their new regulatory objective, I think that they will have more expectations from firms about sanctions. They are starting to do sanctions inspections now of firms that they know work in and around the sanctions space. So what kind of firms are them? Big international ones, really, or niche international firms. So what are sanctions? Well, they're levied by governments to discourage people, businesses, or countries from engaging in some sort of conduct that they don't morally usually approve of. They think it's wrong. It is an offence to make the main sanctions we're dealing with, there are 4 types, but the main ones we're dealing with are financial sanctions. So it would be an offence to make an economic advantage available to a person who is designated a designated person. It's strict liability. In AML, it's different. In AML, you can only commit a money laundering offence, one of the main 14-year offences in AML. You can only commit one of those if you know or suspect that you're dealing with criminal property. Sanctions, it's strict liability. So just the fact that there was a breach of the sanctions, whether you intended to do it or not, is academic. You will be liable. And when it comes to legal services, that can be obviously transacting an asset of a designated person, shares, money, house, property, anything like that. But also, it's not just like financial benefits, it's an economic advantage, including something that's intangible. So then you've got things like intellectual property rights, other rights that they might have, or just giving them some money for something. So damages after an accident, or a settlement after litigation, or a bequest out of out of probate, that kind of stuff. So really, AML, there's bits of your business that are less exposed to AML. Sanctions, theoretically, any bit of your business can be exposed to sanctions. Practically, for most people, hardly ever. But nevertheless, it's strict liability. So as a business, you need to think about what you're going to do about it. And it's probably worth noting that whilst there are UK sanctions that we definitely have to make sure that we comply with, as in we don't do the work if someone's UK sanctioned, you're also going to want to make sure that you're considering US sanctions and EU sanctions. Most of the providers, if you're using electronic verification and they come back with a sanctions check, will be checking all of those different sanctions lists, and should keep them reasonably up to date. It's a good question to ask them if you haven't. How often do you update these? Because sanctions are changing all the time. They just put out a load of sanctions yesterday against people suspected of being involved in Hamas, or people overtly involved in Hamas. So, the sanctions are changing all the time, and you need to make sure that your system that you're using is appropriate to the risks that you're facing. There's 2 other people that are interested in who might ask you about sanctions. Firstly, your bank might ask you about it. We've heard several examples of where Barclays Bank have closed client accounts where they've had monies coming from Russia, or somewhere where there might be a sanctions exposure. And they've actually got a term: you must tell us if you're accepting any money. And they've been asking firms about it. Not a great position to be in, where your client account is getting shut within the next 7 days. You've got to find a new client account from somewhere. Absolute nightmare. So making sure that you understand where your bank is and where you are in relation to sanctions, and that they're happy you're doing robust testing. The other thing is, this year I understand on quite a lot of professional indemnity insurance questionnaires, prop forms from the brokers, they had questions there about any sanctions exposure. How do you make sure that you're not exposed to sanctions, things like that. And that's because they would be subject to the American sanctions if there are any, and because if there's a claim and they're paying out, then they're making economic advantage available too. So that's why they want to know. So look out for them asking you questions about your sanctions program. As I say, there's nothing in the law currently that requires you to have a sanctions compliance program, but I think people are expecting one. The Office for Financial Sanction Implementation, OFSI, they're the people who were responsible for financial sanctions, and they put out some guidance about their expectations of firms, and that was then kind of interpreted for the legal sector by the SRA in the guidance that's on the slide there. But the kind of practical things that you need to do, I think, is conduct a risk assessment, have a little think about the places where sanctions come from. Although that said, there are people in the UK on the sanctions list. What checks you're currently doing and whether they match the risk appetite for your firm. If you feel that you may be exposed to sanctions, or you feel, that some of the work that you do might be exposed to sanctions, normally my advice to clients when they ring me up about this is, unless you're really set up to do sanctions work, as in know how to get the license from OFSI, know how to monitor it, know what you need to report to OFSI, it's probably just disproportionate to the effort, the money you're going to make from those jobs. So quite a lot of people just don't do that work. If you are unsure, and we had quite a lot of these calls to Teal, when the new batch of sanctions people get in touch, and weird things like, I'm acting for a tenant and we found out that the landlord is sanctioned, can we still pay them rent, and things like this. Some things that we can help you with in terms of compliance, but sometimes you need legal advice about particular situations, because you want to make sure you get it right, especially strict liability for you if you get it wrong. And so there are a few people that I recommend. Firstly, following on LinkedIn. Zia Ullah is the main person. He's at Eversheds. And Victoria Turner, who works in his team, she's always posting if there's a change to sanctions. And if any of my clients come in and need legal advice, that's where I send them to for some just practical advice. I do know that they've emailed me last week to say they've launched a new tool that you can kind of look up the sanctions in a particular area. So definitely worth checking out Eversheds sanctions stuff. I'm not on commission for them. It's just really good stuff. So do a risk assessment. I would write a risk assessment. I'd look backwards in doing that risk assessment. How much dealings have we had in the past with any of the jurisdictions or, types of entities that have been have become sanctioned, and think about whether it's ever likely. How many positive sanction hits have you had if you have been doing electronic verification? Probably not a lot. One controversial bit in the sanctions guidance is about counterparties and whether you should be searching the other side. If you follow the logic, if the other side's sanctioned and you do a transaction with them, strict liability, you'll be in trouble too. The SRA guidance seems to suggest that you should be searching counterparties. I would venture to say that you should be doing that on a risk basis, although the law itself isn't risk-based. It depends on how much risk you're prepared to take that you might miss one. So yeah, have a look at the guidance. I have asked the SRA to please revisit that guidance, because I think we do need more guidance on things like counterparties. They have said that they are looking at it, but I don't have an ETO for any other guidance. So you need to look at their guidance in the meantime. And then I do think that you should add sanctions awareness to your training if you don't already have it in your main AML training. I did I was doing some teaching yesterday, like a 30-minute session. I just went through the kinds of sanctions that there are, how sanctions might show up in the work that we do, what red flags to look out for, contrast with AML, why it's different than AML. All of this stuff you can get the detail from out of the guidance to share with people. But I definitely would include it either by circulating the guidance or including it in your training. So regulator activity, as I've already said, I suspect the sanctions compliance, we've got the possible unlimited fines there, and we don't know yet how they're going to use them. So possible unlimited, well, there is actual unlimited, but how are they actually going to use it? There's some links to some cases there that you might find useful. The reason I've included these is if you are the MLRO and you have invested in training, what I normally find with good quality training is that everyone in the business's awareness is increased in relation to AML, but over time it kind of peters off. People get other things that increase their attention and it peters off. One real key way of kind of maintaining the benefit of your investment in training is if people remember it. And that comes with kind of reminders. And so circulating these kinds of cases are good reminders to people about why we ask them to do AML compliance. So the first one there is about that firm I've mentioned a couple of times in Oxford. Another one there about somebody who was trying to keep their best client. And so were scared to ask them questions really, and weren't doing the due diligence that they should be doing. And then another one for persistent AML failing, so over a long period of time. And it doesn't have to be a lot really. for the regulator to go after disciplining. As a result of that action plan I told you about at the very beginning, the 2015 National Risk Assessment saying law firms are high risk, then there's an action plan, and there was a body created called OPBAS, which is the Office for Professional Body Anti-Money Laundering Supervision, OPBAS. And OPBAS's role is to make sure that the supervisors, like the SRA, are doing the right thing, and they're effective in their supervision of the profession. One of the first observations OPBAS meant is there wasn't enough disciplinary activity going on as a deterrent. And so now we see a massive uptick in disciplinary activity. And so, yeah, it is a reality that there are fines, and circulating these kinds of things, money laundering in the news kind of things. Yesterday, I just posted about a solicitor who was prosecuted for tipping off. If you go on a serious fraud office LinkedIn page, you'll see the link to the report about it. So yeah, just circulating those things and reminding people about it. Just a couple of more things to just talk about. And as I say, or as Helen said, in fact, if there are any questions, pop them in the chat and I can deal with them at the end. This fraud is going to be a key focus, and I think it's going to, become the direction of travel for the economic crime agenda that the SRA have been tasked with. And so I think we just need to think about how fraud shows up in our business and where we should be thinking about putting policies, procedures, or controls in place. So obviously a policy is what our position on something, our procedure is what we do about something, a control is how we check it works. And so internal fraud, obviously theft, and the main people that think about, really, if you look about cases about, if you Google like fraud in law firms, you would get a load of cases, news articles of cases. But cashiers, there has been an issue with cashiers who are not particularly well supervised, who are given a lot of trust, committing theft, usually from the office account. It tends to be more controls on the client account, but it's not impossible for the client account. There was a case recently with a trainee was committing fraud by getting payments for, I think it was disbursements in a personal injury case or some personal injury cases, and actually they were being diverted to his own bank account instead of where they should have gone through. I've seen internal fraud with partners. I saw one case where there was a partner and their secretary once in cahoots, who were diverting beneficiaries that were, awards, from people's probate that were supposed to go to charities, and were diverting them to themselves. So the thing is, when you're trying to prevent something, take steps to prove you've tried to prevent something, you literally have to sit in the seat of somebody who is doing it and figure out how they would do it, and then shut down all those opportunities. And you might say with all of those situations, they'd be really hard to spot, and they would. But at least if you've got an awareness of them, you can start to think about processes, sign-off processes, double checking, 4I procedures, to make sure that you're reducing the risk. Didn't help for our firm where it was the partner and the secretary in cahoots, but that's actually incredibly rare for more than one person within a firm to be involved. And then you've got the external fraud risks that you've got. We know about cyber, we know about Friday afternoon frauds and trying to get our bank details from us. We know about interception fraud, email interception fraud, so that they can try and impersonate somebody else and get the client to send money somewhere where they think they're sending it to you, but they're really sending it to the baddie, or alternatively, you think you're sending it to the client and you're really sending it to the baddie. And then you've got mortgage fraud, people obtaining mortgages without the other occupants of the house being aware of it, forging signatures, things like that. So essentially, in all of these cases, we're talking about infiltration. And infiltration is something that you are supposed to be thinking about for AML as well. It's not just using your AML procedures just for AML. They've got a multi-purpose, because you can have infiltration by people, people on the payroll that are actually baddies, or you can have, that tech, that cyber infiltration. So thinking about what policies you've got, training you do, what warning signs you're looking out for those things. And just to kind of square that circle, an awareness within the business that CDD is not just for AML. It definitely is for AML. But when you do identification verification checks on a client, passport for utility bills, your electronic check, you're downloading stuff from Companies House, from a money laundering point of view, that's so you know where to find the person. So if the police did knock on the door, they would come and they know which door to knock on your door. They know which door to knock on to find the baddie. But when it comes to sanctions, you're actually checking that information. So you can check the various lists. And if there is a kind of match, you can either eliminate them or know that they are sanctioned. For fraud, you're getting it so that you know that it's really them, you know. And you know, it kind of is obvious when I say it to you, but people just only get a bit single-minded sometimes and just, this is about AML and I've done my AML checks, but it's more than that. Similarly, when you're looking at purpose and nature. So purpose and nature is where source of funds, source of wealth lives for your checks. And so for money laundering, the question you're asking yourself is this money, is this transaction about layering? Is the money dirty behind it? That's the question you're asking yourself there. Looking at the very same scenario from a sanctions point of view, what you're asking is this an attempt to hide some money to get around some sanctions that we don't know about? Fraud, it's does this actually make sense? What is the purpose for this transaction? Did it have they got a good reason for it? Because baddies don't have a good reason for fraudulent transactions or money laundering transactions for that matter. They're just doing it to, you know, add a layer or to steal money from someone. So, you know, making sure that your training that you're giving people doesn't just focus too much on the anti-money laundering, but they realize that these checks have got kind of multifunction purpose, that they're looking at other things as well. And then the last thing I wanted to tell you about before we get to the end is just about that SARS portal, which was the first thing I told you about on the first slide, that new portal. It takes a little bit of time to register. So if you're the money laundering reporting officer, I would follow that first link. You can just Google SARS portal and find the link, but that's the link to go straight to the page. You'll know that you're at the right place because it's a .gov type page, you know, the black and white with the kind of .gov at the top, and you register there. Take time to register now before you need it. The thing with SARS is they're quite time sensitive things. You don't want to be messing about registering for a new portal the first time you need to do it. So take some time to do that. And then the second link there is to an 11-minute video. You'll find it on the National Crime Agency's YouTube page if you want to go and find it that way. But there's a kind of 11-minute video talking you through how the new portal works. And also a link for feedback on there. With my Law Society hat on and my Teal hat, if you do have any feedback about the SARS portal and you're using it and you want me to pass that on, then please do feel free to get in touch with me. There's a couple of ways to get in touch with me. You can find me via Teal's website, or you can just find me on LinkedIn. I hang out on LinkedIn loads. Amy Bell, send me a connection request. And if I can help you with anything, then let me know. So that's it, I think. I haven't got any questions, but I'm very happy to take some if anyone wants to chat and put anything in the chat. I normally get no questions and I've got a sore hand from writing so much. So if that's you, I hope that's been useful. But yeah, if anyone's got any questions, Helen, I can't see any unless you've got any your end.
No, I can't see any at the moment. Usually what happens is we wait, and then just as we go to leave the meeting, something pops up in the Q&A box. So if you have got a question and you want to write it in, if you just raise your hand just so we know you're typing and don't cut you off, that would be great. If not, thank you. Oh, there we go. We've got
there is one. Yes.
Ken, I'll allow you to talk and you can ask the question over your microphone. So I'll just click that now. If you unmute yourself, Ken, we should be able to hear you. Hi, Ken.
We can't hear you if you are talking.
No, we can't. Ken, are you there? Okay, maybe easier to write it in the Q&A box. Apologies for that. we'll just wait to see if that comes through. In the meantime, if anyone else has got any questions, do let us know. No, I can't see any coming through, and I'm not sure what's happened.
Can't see anything.
Ken, perhaps if you have got a question and we can't hear you, so if you wanted to, if it was all right with Amy, if you wanted to email me or Eloise at SLS, we'll forward that on to Amy and perhaps she can come back to you. I'm not sure whether there's a problem with your microphone or something. Okay, I think that's it. Otherwise, and likewise, anyone else, if you've got any questions that you want to ask after the session, then I'm sure I can forward them on to Amy if she's happy to receive them. So
Yeah, absolutely. Yeah.
thanks so much, Amy, and thanks everyone for
No
joining
problem.
us. See you
Thanks.
soon.
Have a great rest of your day.
Bye bye.
Bye.